Uh, you would recall that we have been discussing the Monopolies and Restrictive Trade Practices Act, and in this particular act, now is the time for us to discuss the Monopolies and Restrictive Trade Practices Commission, right? Just a moment. Yes. So basically, now that you know what was the basic objective behind formulating this particular act, one question that should come to your mind is, how was the implementation of the act ensured? For example, if a particular firm is indulging in some kind of unfair trade practices or some restrictive trade practices or monopolistic trade practices, then how did the act tackle it? For that purpose, the act had a provision for constitution of the MRTP Commission, Monopolies and Restrictive Trade Practices Commission. Now this commission was meant to take up all the cases of violations of the act, all the cases of use of restrictive trade practices or use of monopolistic or unfair trade practices. So the task for the commission was to take up such cases, investigate them, and find out whether a particular firm was actually indulging in these kind of practices and to penalize them, right? So this was the task that was assigned to the MRTP Commission. The commission basically comprised of 2 to 8 members, and the commission used to be headed by a chairman, and the qualification to chair the commission was that the person should be either a sitting judge, a current judge, or an ex-judge of either the Supreme Court or the High Court. So the qualification for the chairman of the commission was that he should either be the current judge, or an ex-judge of the Supreme Court or High Court, or some person who was not the judge but who was qualified to become one. That person could also have become the chairman of the commission. As I said, the chairman had around 2 to 8 members, and the tenure which was set was 5 years, and the maximum number of terms that a particular member could have served were 2, which means in essence a particular member could have served for at most 10 years. 2 terms of 5 years each means 2 into 5 is equal to 10. So at most he could have served for 10 years. Then the qualification was that the person aspiring to be the member of the MRTP Commission should be a domain expert. He should have expertise in commerce, economics, right? So this was the experience, and this was the qualification sought from the aspiring members, right? Now, what was the modus operandi? How did the commission operate? It used to investigate complaints received. So if it received some complaint from somebody, then it would investigate it. In case it did not receive any complaint from somebody, it could still take suo motu action. Now, what is the meaning of suo motu? Suo motu means on its own. It could have taken up a case on its own without somebody lodging a complaint. So there was no need for a complaint to be lodged before it could take some action. There was no such need. It could have taken cognizance on its own. It could have acted on its own. So this is the meaning of suo motu action, right? So there were 2 modes. One was if somebody filed a complaint, if some other firm or some individual filed a complaint regarding a particular firm and claiming that particular firm was using some unfair trade practices or some restrictive trade practices. The other mode was that the commission many a times used to take suo motu action, right? Now, what were the powers that were delegated to the commission? Naturally, the commission had to investigate such cases wherein there is a probable reason to think that some unfair trade practices are being used, or some monopolistic trade practices are being used. So naturally they had to investigate, and to be able to investigate, some powers were delegated to them. What were those powers? They could have summoned, the commission could have summoned and enforced attendance of witnesses, gawah. So the commission was given the authority to invite a witness. If the commission thought that that particular person can provide some good information, some useful information about a particular case which could help its investigation, so it could have summoned, it could have ordered that particular individual, that particular witness to appear. And the commission also had the power to examine the witness, to cross-question him. The commission also had the power to order the witness to present all the relevant documents to it. So the commission could have asked the witness to present all the relevant documents which are related to the investigation in hand, which are related to the case in hand. So production of documents which were in witness custody. So the witness could have been ordered, the witness could be ordered to present whatever documents they have which have a bearing on the case. Again, the commission had the power to ensure compliance with its orders, the power to ensure that its orders were being actually implemented, were being actually followed, its directions were being actually followed, and then to award the compensation. So after the investigation, if the commission deemed it right, it could have also awarded compensation. So that was the task that was assigned to the MRTP Commission, and for that particular task of investigating such unfair trade practices or restrictive trade practices, monopolistic trade practices, the commission was delegated quite a few powers, right? Now let us talk about what were the problems with the MRTP Act 1969. It was not as successful as it was expected to be in curbing the malpractices by the large firms, curbing the monopolistic trade practices or unfair trade practices. There were some reasons behind it. What were the reasons? Let's have a look at them. First reason was that anti-competitive practices were not clearly specified in the Act. What do we mean by anti-competitive? Because the commission was meant to take care of anti-competitive practices. Commission was meant to investigate and penalize. Anti-competitive means monopolistic trade practices. Those firms which are indulging in actions which harm their competitors, which harm their rivals in the same industry, so that they could become a monopoly power, they could become a monopolistic, they could have a monopolistic influence in that particular sector. So that was basically anti-competitive. Now what basically could be termed as an anti-competitive, specifically it was not mentioned. So just it was mentioned that anti-competitive practices had to be investigated, but what exactly is meant by anti-competitive practices, what not mentioned, was not clearly specified. For example, if you look at this example, the anti-competitive practices like cartelization. Cartelization when a number of producers, number of sellers who are selling the same commodity, they come to an informal understanding to keep the prices high, to raise their prices, to raise their sale prices in the market, and this is ultimately detrimental to the customer. Now this is an example of cartelization, right? So for examples, in a particular, there are so many places, if you go there you would find that the auto rickshaw walas, they would informally decide that they are not going to charge less than, let's say, 20 rupees per passenger. Now this becomes cartelization, right? For example, we have got an oil cartel, crude oil cartel, OPEC. It decides the production quantity which ultimately impacts the prices of the commodity in the world market. So that is an example of cartelization. So this was an anti-competitive practice because it was detrimental to the interest of the customers. Again, predatory pricing. Predatory means shikari. So what is predatory pricing? Try and guess. Predatory pricing is when you are keeping your prices so low that the other competitors, they are simply not able to sell at those prices and they simply lose their market share to you. But what is your objective behind keeping the prices low? The objective is that you want to drive out the competition. You want to drive out your rivals from the market, and then once you attain the monopoly influence in that particular market, in that particular item, then what will you do? You will again increase your prices, you will again raise your prices. Now this is the meaning of predatory pricing. Keeping your prices so low that the other rivals in the market are driven out, and once you have attained a monopoly position in the market, then you again raise your prices back. So this is what predatory pricing is. Again, this was an anti-competitive practice, but it was not specifically mentioned like I talked about here. So it was only mentioned in very ambiguous terms that anti-competitive practices have to be reined in, they have to be controlled. But what exactly is meant by anti-competitive practices, that was not very clearly specified. Again, MRTPC Commission, we are talking about the commission here. So MRTP Commission, I hope you remember that we have discussed just now that MRTP Commission was given the task to investigate such trade practices, and they were given so many powers, but one power that was not delegated to them was that they could not have penalized somebody, they could not have imposed a monetary penalty on somebody, on some company, which made them a very, very weak kind of an entity, because nobody was afraid of cease and desist order. Cease means stop, and desist means don't do it again. So that is the meaning of cease. And so if a particular firm was found to be indulging in unfair trade practices or some trade practices which were declared illegal under this particular act, MRTPA, and if these companies were found to be involved in these kind of activities, then the maximum that the MRTP Commission could have done was to order them to stop doing these kind of things or stop these kind of practices and to not continue these kind of practices further. The Commission did not have the power to impose any monetary penalty. So that in a sense actually took out the impact from the MRTP Commission. So the MRTP Commission could not be very impactful because the large firms were not worried about any penalty, any monetary fines being imposed on them. So this was one problem with the MRTP Commission. And then again, one problem with the approach in the MRTP Act was that dominant position per se was considered bad. Dominant position, a company having dominant position per se. What does this mean? A company having dominant position was considered bad. However, ideally what should have been the case? Having a dominant position in a particular sector of economy is not at all bad. In fact, it could be because of your high level of efficiencies, because of your being able to produce quality products, because of you being able to satisfy your customers much more than your rivals, and that is why you were able to become a dominant player in the market. You were able to have a dominant position in the market. But in this particular act, having a dominant position was considered bad. Ideally what should have been the case? Dominant position is not bad. Dominant position, if is being misused by the large firm, by the firm which is dominant in a particular market, then it is not good, then it is counterproductive. So we ideally should not have any problem with a particular firm becoming a dominant firm. No, as I said, this could be because of the managerial efficiencies, because of the high level of productivity, high level of efficiency also. So we should not be having problems with a particular firm becoming a dominant firm. We should be having problem with that particular firm misusing its dominant position in the market. So the misuse of dominant position should have been termed as bad. However, the perception went around was that the MRTP Act is against dominance. Ideally, it should not have been against dominance, it should have been against the misuse of dominance. Right? As I have mentioned it here. Even if no abuse of dominance, then you should not consider the dominant position bad. Now, cumbersome procedures. The procedures in the MRTP Commission were really cumbersome and they were very complicated, time consuming. And then as far as the commission was concerned, it always had a lack of resources, including the manpower, to investigate the cases and to give rulings, and other kind of resources also, for example infrastructure facilities and the kind of support required from other departments and divisions in the government. So that was also missing, because of which the MRTP Commission could not be that effective. Again, in 1991, you would be reading about this a little later. In 1991, India opened up its economy, and this phase is known as the LPG phase, liberalization, privatization, globalization phase. And this was in the year 1991, and India became a relatively more open economy at that point of time. And 1991, basically we actually came up with a new industrial policy which opened up the Indian economy. Now the MRTP Act was meant for pre-91 phase, and it was soon found out after 1991 that MRTP Act is not going to be that relevant, it's not going to be that effective in the post-1991 or the post-91 reform era. 91 developments are known as reforms because there were so many reforms which were brought about in the economy. So it was found out that the MRTP Act and MRTP Commission is not going to serve the purpose in the post-reform era, post-1991 era, and that was why in 2002 the MRTP Act was repealed and the Competition Act took over. It was replaced by the Competition Act. This is okay. Now let's understand how the laws have evolved. You know that MRTP Act 1969, we have had a discussion on what MRTP Act entailed and what all provisions were there. Now please understand that basically MRTP Act actually talked about three categories of illegal business practices: the monopolistic trade practice, the restrictive trade practice, and the unfair trade practice. Now out of these, as I said, the act was repealed in 2002 and it was replaced by the Competition Act. We'll understand this thing now. Now out of the three practices which were termed as illegal under this act of MRTP 1969, these two, the monopolistic trade practices and restrictive trade practices, came under the purview of the Competition Act 2002. Now remember this. While the third one came under the purview of Consumer Protection Act 1986. Now you have a look at the definitions which we had discussed regarding the unfair trade practices. I have given you some examples of unfair trade practices. These are those practices, for example, false claims, duping the customer, advertising bargain sales while when the customer turns up, not giving him any discount, not selling at the bargain price which was advertised, false claims. Now these were unfair trade practices and they came under the purview of the Consumer Protection Act. While the first two, the monopolistic trade practices and the restrictive trade practices or the anti-competitive trade practices, basically came under the purview of Competition Act 2002. Now the thing is that the syllabus only talks about the MRTP Act 1969. However, whenever you are being asked a question on MRTP Act 1969, you should always at the end mention that it has now been repealed and has been replaced by the Competition Act 2002, while the unfair trade practices part of the MRTP Act is now coming under the purview of the Consumer Protection Act 1986. And you would remember now that Consumer Protection Act in itself, the act itself was repealed and it was replaced by the Consumer Protection Act 2019. So this is how the laws have evolved over the years, right? So now let us have a brief discussion on Competition Act 2002, just to understand how was it different from the MRTP Act and what were the drawbacks in the MRTP Act that were being taken care of by the Competition Act 2002. Let's have a look. Again, the objective of this Competition Act 2002 was to implement and enforce the competition policy. So earlier in MRTP Act we said that we do not want monopolies. Now in the Competition Act what did we say? We changed the tone of the act. What did we say? We did not say that we do not want monopolies. We said we want competition, and that is, see the difference in the name. There we said we are against monopolies. Here we are not saying. We are saying the same thing, but we are saying it. We are putting it across in a very different manner, in a more positive manner. We are saying we want competition. So we are essentially saying the same thing, but we are putting it across in a more positive manner. And this is an indication of how the regulation and the government intervention in businesses has been slowly and gradually decreasing over the years. Earlier we said we do not want this. Now we are saying we encourage competition. Earlier we said we do not want monopolies. Now we are saying we are encouraging competition. So the environment that the government is trying to create is much less restrictive than it used to be the case in 1970s and 80s. And this is an example of how Indian governments have loosened their grasp on the businesses over the years, right? Again, so Competition Act 2002 actually established the Competition Commission, which actually replaced the MRTP Commission, right? Now, the job of the Competition Commission was to promote free and fair competition, inquire into anti-competitive agreements or abuse of dominance. So, free and fair competition, as I said, the whole objective was to promote competition, not to stop. Actually, we are preventing monopolies, but the concept is we have to promote competition, right? And inquire into anti-competitive agreements or abuse of dominance. A particular firm is very dominant in a particular sector. If they are abusing their dominance, if they are misusing their dominance to exploit the consumers, then this was to be inquired into by the Competition Commission. And now one more thing that the Competition Commission looks at is whenever there are such agreements among different corporate entities, for example, vertical and horizontal integration and mergers and acquisitions. I hope you know what mergers and acquisitions are. Mergers is when two companies come together. You have heard of how very recently, around 2-3 years back, the merger between the Vodafone and Idea took place. So that is an example of merger. Acquisition is when a firm actually purchases another firm. That is why it's called an acquisition. So merger is between two equals, like Vodafone Idea. However, in acquisition, a particular firm now gobbles up another firm. So this firm which has acquired remains, while the firm which has got acquired, it would not remain anymore. It would lose its existence. Now this is an example of acquisition, right? For example, I'll give you an example of acquisition. At some point of time, around 8 to 10 years ago, Jet Sahara deal took place. It was more of an acquisition. Sahara Airlines existed at that point of time. It was basically acquired by the Jet Airlines, and after that only the Jet Airlines remained. Sahara lost its existence because it got gobbled up by Jet. So that is an example of acquisition. Now what is the example of vertical and horizontal integration? Vertical integration is, let's say I'm in the business of I'll give you some examples from our surroundings. Let's say I'm in the business of growing potatoes, and then I sell it to a dhaba owner who uses these potatoes to produce aloo ka parathas, and then he sells aloo ka parathas to the end customers, right? Now what is the meaning of vertical integration? The vertical integration could be when the person who is growing the who is growing the potatoes in his fields, then he also acquires control of the dhaba. So this is vertical integration. And why is it vertical? Because integrating the next step in the value chain. The first step was producing the potatoes, and the second step was processing them into aloo ka parathas. So these were earlier being jobs, these things were earlier being done by two different entities. But if the aloo farmer, the potato farmer, he also acquires the dhaba, then it becomes a vertical integration, and it would be called a downward vertical integration, right? On the other hand, if the dhaba owner acquires the field and he starts producing his own potatoes. He acquires the field of the potato farmers and starts producing his own potatoes. Then again it would be vertical integration, but in this case it would be upward vertical integration. Is this understood? If you still find it a little doubtful, if you are still not very clear about this, then you can refer to the various notes available on the internet. You can always call me back also. So this is what basically vertical and horizontal integrations are, right? So let's say you must have seen Maruti dealerships. Maruti produces, manufactures, assembles cars, and then it basically sells through dealerships. Dealerships are owned by entrepreneurs in different parts of the country, right? If Maruti acquires its dealership, now this would be an example of vertical integration and downward vertical integration. Is this fine? Right? On the other hand, if a particular dealer who has been selling Maruti cars, now he acquires the Maruti firm and starts assembling the car on his own, then it would again be vertical integration, but this time it would be upward vertical integration, right? What do we mean by horizontal integration? At this, if you integrate with another firm at the same level, so I'll give you another example. If a dhaba owner acquires another dhaba, then it would be horizontal integration. Is this understood? Because they are at the same level of the value chain. And what is the value chain? Aloo, potato, the value increases when you convert it into aloo ka parotha. Is this okay? So in such cases, in such combinations, the companies which are planning to go for such combinations, they have to first go to the Competition Commission and they have to seek its approval, because the Competition Commission will try and look into the fact that this kind of combinations, they should not be anti-competitive. They should not reduce competition in the market. And if it feels that the competition is being reduced because of these kind of combinations, what will it do? It will not allow such combinations. So whenever such combinations are taking place, which means when Vodafone and Idea decided to merge, they must have taken a clearance from the Competition Commission, right? Okay. Now this time Competition Commission was given the authority to not only come up with cease and desist directions and orders, but also punish and penalize anti-competitive business practices. So they were given the authority to impose penalties, impose monetary penalties on the companies which were seen to be adopting anti-competitive practices. Now this was an addition to its power if you compare it with the MRTP Commission. And with the Commission, I hope I have said this particular thing, that Competition Commission basically is replacing MRTP Commission, right? So in that sense, Competition Commission has more powers than the MRTP Commission had. Again, one more job that is done by Competition Commission is competition advocacy. Advocacy is talking about the benefits of competition, making people aware about it, generating popular support, creating literature and promoting, creating literature and then circulate it among people, telling people why competition is important, so that a favorable perception can be created regarding competition among the customers and among the companies also. Naturally, if this favorable perception is created, there would be less chances of anti-competitive policies being adopted by the firms also, and the consumers would also be more enthusiastic about, more keen to put pressure on firms not to adopt such anti-competitive practices. So that is why this advocacy is a very, very important part, and that is also being done by the Competition Commission. They also involve in competition advocacy. They create literature regarding the benefits of competition, then they circulate it. They run various awareness programs, and they also build capacity. Capacity building is to train the human resources in various government entities, organizations, to keep looking for such anti-competitive practices and to deal with such anti-competitive practices. So this is again the job of the Competition Commission. Now, as I said, raising public awareness is also another job of the Competition Commission, right? So these were the jobs these were the tasks which have been now delegated to the Competition Commission. Is this fine? I hope this has given you an idea of how Competition Commission is more effective than the MRTP Commission used to be, and how Competition Act 2002 is an improvement over the MRTP Act 1969. Thank you very much.